So this is a discussion about alternative enforcement under the California Labor Code. California's Labor Code contains certain alternative enforcement provisions in Division 1, Chapter 8, which was added in 2023 by Chapter 659. Labor Code Section 180 defines the term public prosecutor to mean the Attorney General, a district attorney, a city attorney, a county counsel, or any other city or county prosecutor. Section 181 authorizes a public prosecutor to prosecute an action either civilly or criminally for a violation of specified labor code provisions or to enforce those provisions of the code independently. And monies recovered by public prosecutors under the labor code are applied first to payments such as wages, damages, and other penalties due to affected workers. All civil penalties recovered by a public prosecutor are paid to the general fund of the state unless otherwise specified. And an act of a public prosecutor is limited to redressing violations occurring within the public prosecutor's geographic jurisdiction unless the public prosecutor has statewide authority. In addition, a public prosecutor may seek injunctive relief to prevent continued violations of specified labor code sections. The court may award a prevailing plaintiff in that action reasonable attorney's fees and costs, including expert witness fees and costs. A public prosecutor is required to provide a 14-day notice to the Division of Labor Standards Enforcement or the Labor Commissioner prior to prosecuting an action under this section. However, a public prosecutor's failure to provide this notice is not a defense to the action. In addition, the DLSE has the right to intervene in any court proceedings brought by a public prosecutor unless the public prosecutor has statewide authority, in which case intervention in a proceeding is permissive. This particular provision has a sunset date of January 1, 2029. And finally, there's Section 182 of the Labor Code that specifies in any action initiated by a public prosecutor or the labor commissioner to enforce the California Labor Code, any individual agreement between a worker and an employer that purports to limit representative actions or to mandate private arbitration does not have any effect on the authority of the public prosecutor nor on the labor commissioner to enforce the provisions of the California Labor Code.